Hearing in the appeal Cardtronics UK Ltd and others against Sykes and others.
Mr. Moorshead.
Yes. Lord, I'm sorry, you don't know where to look. I hope this is convenient, but we've agreed that it's given the numbers involved, it's best if the person speaking the court addresses the court in the old-fashioned way from the middle of the courtroom. I hope that's acceptable.
Well, it's a new-fashioned way as well, I think, isn't it?
The housekeeping matters I need to deal with after the introductions are mercifully brief, but I ought to begin with introductions. I, of course, represent the Valuation Officers with my learned friend, Miss Ward. Representing the first respondents, Cardtronics UK Ltd, are Mr. Kalinsky, Queen's Counsel, and Luke Wilcox, who sits at the back at the moment. Representing Tesco Stores Limited and Tesco Personal Finance PLC are Mr. Mould, Queen's Counsel, and Guy Williams, who sit at the end on the front row. Representing Sainsbury's Supermarkets Limited and Sainsbury's Bank PLC are Mr. Drabble, Queen's Counsel, and Mr. Lewsley, both of whom sit next to me. And representing the Cooperative Group Limited are Mr. Mould, Queen's Counsel, and Mr. Lewsley. So far as concerns housekeeping, may I check that the court has received this slim volume called Replacement Documents, which includes a perfected version of the Statement of Facts and Issues, and also a fuller report of the Clydesdale case, which is important for the respondents.
Yes.
Sent electronically?
Yes.
It has, my lord. It's in the latest version of the
Right,
USB
thank you very
stick.
much.
The only other documents that I would... Sorry.
The only thing I've got, well, I think I have an awful suspicion it's with the papers from yesterday's case. Which I'm afraid is confusion. Is there a spare one by any chance?
Mr. Wilcox says he has a spare.
Oh, we got one. We got one here.
Thank you.
Thank you.
I think there's now being handed up to your lordships and my lady two documents. One is some...
Yes, I remember being rather surprised that the Clydesdale Bank case was relevant to listed buildings.
Yes. The first is the non-domestic rating, telecommunications apparatus, England Regulations 2000. The import of those will not immediately strike anyone, I suspect, but if we can park those for the time being. The next is a note that I have drafted in response to my Lord Carnwath's question raised yesterday about how the facts of the different ATMs relate to each other. What are the distinctive features? And I'll go through that orally. It's just to save your lordships and my lady having to write everything down as we do that exercise on the facts. So far as concerns timetabling, subject, of course, to any indication from the court, I am expecting to need to address the court until 3:45. I will aim for 3:30 today. It's going to be difficult for me to compress it much, but I will do what I can, I promise you.
You can take it we have read the arguments.
I'm grateful. The respondents are confident that they can conclude within the time allowed, even bearing in mind the special event that takes place tomorrow morning. I'm going to start by indicating the different categories of ATM and how they've been treated below. That's also going to serve, as I suggest, a sufficient account of the observable facts. So I'm not going to spend very long on the facts. I propose then to examine the contracts. I will then try to explain the basic problems in this case in a bird's eye view fashion, which I hope will help isolate some of the points of principle, then the statutory framework, and then the authorities. I hope that's an acceptable course. May I then start with this type note and indicate the different categories of ATM and the possible differences between them and the way they've been treated by the courts below. The first available distinction is between ATMs facing externally and those facing internally, where both are built in. So the shorthand is a fixed ATM that's external or a fixed ATM that's internal. At the risk of sort of showing the court something it sees almost every day of the week, probably anyway, a photograph of an external ATM, which is reasonably typical of the kind under examination can be seen at page 4, MS, memory stick page 402 and 403. These are examples from Tesco. If you wanted to see the example, another example from a smaller shop in the high street, again, one can easily see this from the photograph at page 419, which is an example of one of Cardtronics' installations. So those are built-in or fixed external ATMs. To see what we mean by built-in or fixed internal ATMs, may I invite the court to look at memory stick page 399. This is an example of ATMs accessible within a Tesco store, but as your lordships and my lady can see, they are situated in a recessed sort of purpose-built area. And in paragraph 1.3 of my note, I don't think I need read this out, but I've listed each of the ATMs which fall in the different categories. So if your lordships and my lady need a convenient checkpoint at any stage, there it is, and I hope that's accurate.
It's quite interesting, the photographs. So you see a couple of cash machines, and then next to them is a machine for dealing with lottery cards.
Coinstar.
Well, there's a Coinstar one as well. Between the, and I presume that's the machine that gives you change. And between that and the cash machines, there's some other sort of machine there, which I thought might be the lottery symbol, but maybe it's something else.
I'm not sure.
Yeah.
Is the Coinstar machine separately rated?
I don't know the answer to that, and I don't know what the contractual arrangements are that relate to its placement on the store.
Yeah.
I don't know, for example, whether it's, well, we'll look at the contracts in due course, but that may be a material difference.
Yes, we can see how this area of flooring is also used to store what look like crates of beer and a waste paper bin.
Yes, there's a lot going on in the area around the ATM sites. Our point, as my Lord appreciates, is that if you focus, as we say you should, on the site actually occupied by each ATM, there's only one thing going on. And the question is, who's doing it?
Page 400.
Yes.
Right-hand housing extended.
I'm going to come on to that. That's a separate available point of distinction. I will come on to that. But, my Lords, just may I complete this part of the introduction by going to the foot of page 1 of my note, where I've tabulated what the differences that are said to have been in the courts below. The Valuation Tribunal for England, which was the first tribunal to look at this, said that that distinction, external, internal, makes no difference. Each is a separate unit of occupation and therefore rateable. I've given the reference to that. The upper tribunal said it makes a crucial difference because outward-facing machines are separate units of occupation and therefore rateable. But if inward-facing, then they're predominantly serving the store's retail purpose, not the bank's ATM purpose. And I've given the references for that, the main references. And the Court of Appeal said it makes no difference, but because each ATM serves predominantly the store's retail purpose. So you see there's a complete swing in the judicial opinion from the Valuation Tribunal for England, which was completely in my favour, the upper tribunal, which was partly in favour and partly against, to the Court of Appeal, which is completely against.
When did it first occur to anyone that these were separately rateable?
Well, before Stringer. So that there's, it's not a new development.
No, well, we've had a succession of cases that we've seen, and then it's sort of gradually built up from that, is it? That's
exactly right. There is a pressure that's built up, and the view certainly has been taken that before this goes any further, we need a definitive answer. Because on our case, as you appreciate, the law has taken a very seriously wrong turn.
One thing I mean, something may not be relevant, is the value. There seems to be sort of, we're not concerned with the figures, seems to be, except that there seem to be figures which turn around. But there must be some reason why, if you have to disregard the value of the ATM machine for valuation purposes, the bit of land or bit of floor on which it sits acquires mysteriously a value. There must be some answer to that.
Well, I'm going to explain that in more detail
Okay,
in
well,
a
we'll
moment,
come to it.
of course. But the short answer is that the rent payable for any land depends on what you're acquiring. You might be acquiring the land and whatever machinery is situated on it, in which case you don't have to pay for the machinery. You don't have to bring on.
I mean, your point is you've got 4 square feet of property which can be valued at retail purposes, perhaps, not as an ATM machine.
Yes.
Is
Not
that
as the
a
site
simple
for an
term?
ATM machine. The site for an ATM machine.
Okay.
But it's better probably to let that
Yes,
point
I know.
unfold. The next available distinction at the foot of my page is whether the machine is built-in or movable. We've already seen a photograph of a built-in ATM, but movable ATMs, if the court would like to see an example of those, there's a photograph at page 404. This is the example the upper tribunal gave. It said, well, this ATM, do you see it in the corner there? That's said to be movable.
So which page was that?
404, my lord. And the only example in the ATMs before the court is the one I've just shown you. It's in Tesco's rugby store. Now, the approach of the tribunals below was, as I've set out. At first instance, there was no distinction drawn. As the tribunal pointed out, the points that were then being run by what are now the respondents, the ratepayers, were in relation to all ATM sites indiscriminately. In the upper tribunal, a distinction was drawn of the tribunal's own volition. It said that I'm not sure if it was of its own volition, that may be unfair. Anyway, the tribunal drew the distinction between movable and fixed units, and it said that the site of a movable ATM was not a hereditament, even if occupied for a more than transient period. The Court of Appeal agreed with the upper tribunal. The next potential distinction is the question of where do personnel stand when they're servicing the ATM? And the range of examples can be detected from 3 photos, page 386. This is inside Sainsbury's secure room. They've got a special area set aside, which they keep their own, the store keeps its own cash in this room. And also, it's available for servicing the ATM in a secure fashion. So that's separate from the shop floor. Another method, and this is the point my Lord Kitchen identified, is illustrated in various photographs. The photograph at page 400 is a good example. Another way of servicing these units is to pull out a secure hood, such as you see at page 400. And that gives you security while you're servicing and replenishing the machine.
Sorry, just going back to page 386.
My Lord.
That's a filing machine sitting.
Correct. It looks a bit like a filing cabinet in this photograph, but that's only because of the, the lack of contrast. But that's it.
And the faces.
The face is on the outside.
On the outside wall.
Correct. Yeah. My Lord, it's a convenient moment to make this brief point. What's going on inside that enclosure is there is a robot. There's a robot enclosed by a metal box doing the job which in the old days would have needed more space and a person. And it's important to understand that that is what the box is doing. Because the person inside the box would have been an employee of the bank. And the robot now doing that job is the bank's employee in modern form.
Or you would have got cash back at the till from a member
That's
of
another,
the staff.
exactly so. Really. That's another way of doing it.
That would have been the supermarket staff.
Exactly so. The supermarket had a choice. It's always got a choice about how it provides these services in retail premises. If it goes down the route of letting somebody in to provide that service, and that person, whether it needs to or chooses to, occupy land to do it, then there's an occupation of land. And rates are a tax on people who occupy land. Unless that principle is recognised and given effect to, you create a big problem in rating. You have to explain why one ratepayer in an identical situation is rated, but the other one is not. That's why this is a point of great importance, and this is how the law, I'm afraid, has taken a wrong turning with Clydesdale. I'm going to develop that a little more fully in a moment, but my lady, your ladyship is exactly right to focus on that distinction. So that's an available distinction on the facts. The other, at the other end of the spectrum, I need to show you to complete this point, page 422. In the smaller convenience type stores where Cardtronics typically puts its ATMs, you can see that there's really no enclosure at all. What happens is that the back end of the machine gets pulled out, and anyone servicing it needs to occupy an undifferentiated part of the shop space in order to do the servicing and the replenishment.
Well, that machine is fixed, is it?
I beg your pardon, my lord?
Sorry, in this page 422 we're looking at.
Yes, my lord.
Where does the customer's on the other side of the wall?
That's right. All this photo is doing is showing the machine being serviced.
As it's being pulled out.
The innards have been pulled out inside, but the customer is on the other side of the wall, outside on the street, facing a panel. I think what the customer is looking at is shown on page 419. So how was this available distinction treated below? The first instance tribunal and the Court of Appeal didn't refer to it at all. The upper tribunal recorded the arrangements, but didn't suggest that it makes any difference. And I don't think anyone is majoring on that point. The next available distinction is how much, if at all, does the ATM in practice interfere with the host's retail operation on the store? And again, there's a range of possible answers to that. It ranges from some to none. You can see at the most extreme example, the photograph we've just looked at. Clearly, while this machine in a Cardtronics location is being serviced, there's considerable interference with the host store. But compare that with the Sainsbury's operation. When you're servicing that inside a Sainsbury's secure room, there's no interference with the host store. That's an available distinction. Below, at first instance, it wasn't considered to be relevant. The upper tribunal considered it and thought it was a point against Cardtronics. It thought, well, the fact that the ATM operator has to interfere with the host's store is a sign of control by the ATM over the store. I don't attach weight to that reasoning for reasons that will become clear. I say that falls into the trap of looking at things the wrong way around, but that's what the upper tribunal did with it. The Court of Appeal didn't refer to it, other than in recording Mr. Kalinski's submission that the upper tribunal was wrong to do what it had just done, and as I've just described it. The next available distinction on the facts between these categories of ATM is this. What, if any, involvement does the store's staff have in day-to-day maintenance and replenishment? And again, there's a range. The most active are Sainsbury's. The least active, in fact, the inactive, are the staff of convenience stores in the Cardtronics locations. The best place to find a tabulation of this, my lords and my lady, is in the first instance tribunal's decision at MS page 352 to 354. Paragraphs 76 and 77, the member here directs himself by reference to the agreements in paragraph 76. The granting of the licence or agreement clearly grants obligations, albeit minor and basic ones on both parties. Miss Ward helpfully set out a list of the arguments and evidence put forward by the appellants, which I list below. None of them interfere with the enjoyment by the ATM operators of the premises in his possession for the purposes of which he enjoys them. Some may place restriction on the time when matters such as repairs or replenishing of the machine can take place, but in real terms are minor matters, and those that many tenants in the real world face. A shopkeeper may have restrictions placed on him by the owner of the surrounding land on when deliveries or repairs can be undertaken, and so on. Your Lordship, I invite your Lordships to read that paragraph. But then there is this list of what each host does in practice by way of activity, to use a neutral term, in relation to each site. How was that dealt with below? Well, in the paragraphs I've just shown the court, the first instance tribunal analysed the contracts and said that all the servicing which took place was indistinguishable from services commonly provided by landlords to tenants and was therefore irrelevant. The upper tribunal agreed that the details of the servicing arrangements were irrelevant, and I've given the references to that. The Court of Appeal said that staff involvement was evidence of the host retaining control over the ATM sites, though it didn't notice that Sainsbury's is the only case where staff have a sustained role, and it conducted no analysis of the contracts to see in what capacity any servicing was provided by the store's staff. Before we leave the photographs, can I just go back to make one point while they're fresh in mind about a feature of the Cardtronics stores that Mr. Kalinsky's attached weight to. Perhaps I could ask you to go back to page 420. Where Mr. Kalinsky, I think, would draw attention to the fact that the occupier of the store, do you see the site of the ATM is on the right-hand side of the photograph, behind some shelves of magazines. Mr. Kalinsky would point out that the occupier of the store has put magazines on top of the ATM. And I think Mr. Kalinsky would say, well, that shows continuing use by the store of the ATM site. I'd invite you, when reflecting on that submission, to compare the situation of, say, a kiosk in a railway station with a departure board on top of it. Why does placing a departure board on top of a kiosk such as was considered in Southern Railway mean that the host is exercising control over the kiosk and what goes on inside it? It doesn't at all, we suggest. And neither does it create or indicate that there's any difficulty in telling the kiosk apart from the station or the site of the ATM from the rest of the shop. What you're looking at in photograph 420, as elsewhere, is a clearly differentiated piece of land.
Whilst we just got the picture, and remembering the picture of the machine being refilled,
Yes.
who, on your argument, is rateable in respect of the corridor where the machine...
The shop.
The shop.
And that, my lady, is in the same way that if you have a shopping unit in a mall, you can imagine Westfield, sometimes the shop has to be stopped up by trolleys parked outside the shop. It's an ordinary easement. It's just, that's the upper tribunal accepted that. So that's how that's explained.
Is it relevant that the location of an ATM within a store, or possibly also outside one, requires the consent of the store.
Well, it's a factor to which I think the Court of Appeal attached attention. But when one analyses that through, one immediately confronts the difficulty of understanding how that can make a difference to the use of the unit while it is in operation. Your Lordship will, I'm jumping ahead, but your Lordship will remember that there are cases, Southern Railway is an example of this, where the railway station itself was shut under the control of the railway company without the say-so of the occupiers. The consent of the company was at all times needed in that sense to go on and have the benefit of occupying the kiosks and the showcases. Similarly, in the airport case, the old Consort case, as we'll see in a moment, the ability of the cafe, for example, to operate as a cafe depended on the airport being open and depended on the consent of the Minister for Transport who occupied the airport. And as we'll see when we go through the cases, the fact that you can only occupy your hereditament subject to the control of the host in relation to the host hereditament doesn't affect rateability. The example of the shopping mart is probably the clearest example. There too, individual shops, undoubtedly individual hereditaments, nevertheless can't be traded from unless the shopping centre is open.
Well, on your thesis, the hereditament is created when consent is given by the store to the installation of an ATM machine. Well, is it extinguished when if the store decides that they don't want the ATM any longer?
Yes, that's right.
So you've got a temporary hereditament.
Well, it's not. It's temporary. It's potentially temporary. Of course, if on the facts it were the case that ATMs were transient things, that would be a factor against rateability. We've always accepted that. But
well, what does transient things mean in that context?
Well, my Lord,
I mean, if it's subject to the continuing consent of the store.
My Lord, it's been held, and we'll see in the authorities, a tenant at will is nevertheless rateable. A tenant at will is precisely a person whose occupation is vulnerable to being terminated like that. This is one of the problems in rating, and my Lord, I detect a trace of it in my Lord's questions, is the problem of unpicking the question of what is your title to land. It's a problem that used to vex the courts a lot, from the question of what are the de facto indicia of occupation. Rating is only interested in the latter. It's only interested in the question, is there an occupation? It's not interested in what is the legal title to occupy. And that explains why my Lord's question embodies a potential problem in rating. We do not look at the question, is there a right to terminate? We look at the question, is the occupation permanent?
But you'll come on to the point that's made against you about the need for there to be an identifiable hereditament, even if it is not occupied.
Yes. Well, I'm happy to come on to it. I don't see why, but I can say in a nutshell that one way of illustrating this is the one we've given in our printed case. Better to take it one stage at a time, though, probably. Otherwise, I'm going to fall behind time. Can I then look at the contracts and show you the contractual arrangements? Because these are of significant importance. The first I'd like to show the court, please, is the Cardtronics agreement. This is at page 306. No, I'm not sure it is. I'm using the wrong page number. It's not memory stick page 306. It's memory stick page 548. I apologise. It isn't very clear. I think some larger copies are available if the court would find them helpful. May I call attention to, on page 548, under terms, does the court see fixed rental £6,000 a year, plus 25 pence on transactions over £12.50 per month for a 5-year term? At the top of the next page, can I call attention to the recitals? The licensee is the owner of automated teller machines which it installs in commercial premises to which members of the public have access. The licensor is the owner of the premises. The licensee wishes to install their ATM in the licensor's premises, and the licensor wishes to grant the licensee a license to install their
Machines.
machine
At the premises.
on the terms set out in this license. The license, in its operative part, starts at clause 2.1, in consideration, and your lordships and my lady see at 2.1.1, a license I better read the whole of it, in consideration of the payment of the license fee by the licensee to the licensor, and subject to the terms of this license, the licensor grants to the licensee, its agents, and its contractors a license to enter into and onto the premises during operating hours, both with and without workmen and equipment, for the following purposes: install the equipment upon or within the premises at such prominent and readily accessible by the public locations, and by such means as shall first be agreed with the licensor, such agreement not to be unreasonably withheld, and so on. Contract the equipment to connect the equipment to any existing electricity supply, and install a telecommunications supply cable, and thereafter inspect and maintain, and so on. 2.3, the licensor hereby grants a right for any CIT personnel to enter into and onto the premises during the operating hours for the purposes of collecting or delivering cash to the ATMs. And then the licensor grants in 2.4 a right for any employee or agent of the licensee to enter into and onto the premises during the operating hours for the purpose of maintaining and repairing or removing the ATMs, and to install promotional material. At clause 3.2, the licensee is entitled at its own behest to relocate the premises, the equipment within the premises at any time with the prior consent of the licensor, subject to consent not to be unreasonably withheld or delayed. And then there are, perhaps I needn't read them all out, but the court can see there are the sorts of provision one would expect in a license that has to regulate how these things are going to work in practice.
Whereas, if this is important, I'd like a better copy, but where, presumably there's somewhere in the judgments below, these terms are set out or summarised clearly somewhere.
A summary of these terms.
Well, yes, rather than sort of trying
Oh yes, no, absolutely.
wade through all this, it'd be helpful to have a sort of...
Yes, there are two good places. The Court of Appeal doesn't really do this, unfortunately, but the First Instance Tribunal does in the paragraphs just before those which I showed the court. I think you'd have to go back 2 or 3 pages to memory stick page 350 to 351.
Yeah, well, we can look at that.
The upper tribunal also gives a fuller summary, but in a less tabular form.
But how much turns on the precise these agreements?
The point about the Cardtronics agreement is that there is no provision here for the host to do anything in relation to the ATM. All servicing and maintenance is done by the bank. So we don't have the complication of having to unpick why any host employee is doing stuff to the ATM. It's the cleanest in that sense. The cooperative contract is at memory stick page 525. And at 527, again, are recitals. The bank is seeking to install and operate ATMs in locations at premises other than its own. the Society has agreed to accept the installation and operation of bank ATMs on its premises and agrees to grant an appropriate licence to enable the bank to do so. It grants a licence to the bank to install and operate the ATMs, and we see similar provisions about the location, paragraph 3.1, a right of first refusal, and there are provisions dealing with the selection of a location at 3.2 to 3.5. There's provision in clause 4.1 to 4.3 which refers to the history and is slightly difficult to unpick in a vacuum, but it's dealing with how the money matters should stand between these parties in view of past relations between them. There are provisions, again, of a kind one would expect in any licence agreement, including in clause 19 a non-partnership agreement. This is page 532. Nothing shall be deemed to constitute any legal binding partnership pursuant to the Partnership Act or joint venture of any kind between the parties. And this is another example of an agreement where the practical arrangements for servicing and maintaining the ATM rest entirely with the bank. You see that at pages 539 and 540. The next agreement is the Tesco agreement. This is at page memory stick 499. In a form that's now perhaps familiar in general terms, at memory stick 504. 2.1, grant of exclusivity. This is the first example that uses the word exclusivity, but you'll appreciate that the effect of the agreements we've looked at already is to confer exclusive rights on the ATM operators in relation to the sites occupied by the machine. But the Tesco agreement spells it out. 2.1, in consideration of the payment of the fees and subject to the terms of this agreement, Tesco grants to TPF the sole and exclusive right from the commencement date and throughout the term of this agreement to install and or operate ATMs at Tesco premises. Can I pause here to make an important submission? The first instance tribunal instantly understood the importance of these provisions in the passages to which I have referred to. If you ask the question at any point, who is operating these machines, or who has the right to operate these machines, the answer is always and only the bank. It is the bank's exclusive right to install and operate each ATM.
But isn't this exclusivity vis-à-vis other banks that might want to come along?
Well, but my lady, of course, what it also does is mean that it's not Tesco that is operating the ATM.
But that's not the purpose of this grant of exclusivity, is it?
But, well, my lady, 2.2.
Yeah.
Tesco agrees that it will not, without TPF's prior written consent during the term of this agreement, either itself or permit any other person other than TPF to install and or operate ATMs at Tesco.
This is other ATMs.
No.
It's not talking about this ATM.
But you're absolutely right, my lady. Nevertheless, that distinction, I submit, is a partial one only. The effect of these licences is to confer, and confer only on the bank, the right to operate each site, each ATM site. And we see this continuing at paragraph 6.1, clause 6.1. it's TPF that will operate and maintain the TPF ATMs. And it may perform its obligations through subcontractors and sub-subcontractors. And that's what Tesco, in fact, did. So the Tesco ATMs are another example of minimal involvement by the store's staff. The store's staff had roles in facilitating access, where locks had to be opened and so on. But servicing and maintenance is done by subcontractors of the bank. 6.5 is interesting. Save as otherwise agreed in writing by the parties, Tesco will not have or require any rights, charges or liens over or in respect of the TPF ATMs or the cash and stationery used in them. My lady, some of these agreements are more clear than others. I appreciate that. But when you stand back and examine the totality of their effect, it is absolutely clear that the host is excluding itself from any right to use these sites. It's really not sustainable to suggest otherwise.
From any right to use the sites or from operating a machine of this kind in the store?
To occupy the site by operating a machine from it.
Well, they are both interconnected. I mean, does occupation flow inexorably from the operation of the machine?
It's always going to depend to some extent on the circumstances, but where the operation is in the shape we find here, a robot inside a self-contained kiosk, undoubtedly there is occupation, no less than if instead of the robot there was a person inside a booth, behind a screen, providing cash dispensing services.
Surprise, I mean, in a way, this emphasis on the terms of the agreement seems a bit odd, because obviously the agreements can be changed. And I don't know whether these were drawn up with the rating in mind, but is there some reason why it has to be the bank which is operating it, because it's a banking operation?
My lord, that's exactly right. There was evidence given that for the stores themselves to have operated these ATMs, they'd have had to cross regulatory thresholds, which would have been expensive to satisfy.
That's what I thought. So there's a substantive reason.
There's a substantive reason
they're done in this form.
For choosing to provide this service by letting someone else into occupation to do it. There's a reason for that. It's not capricious.
So it wasn't feasible for the bank to satisfy the regulatory requirements and then give over the operation to the store.
Well, what happens when one studies these agreements is that is not what happened.
No, quite, but I'm just exploring whether that was a feasible proposition.
It hasn't been examined what regulations applied and the extent to which it would have been possible for the bank to allow an independent contractor to come and do the business. But that informs the question when one examines what was the capacity of the host's staff when they were servicing these agreements. Our analysis is they were simply the subcontractors of the bank. Milady, just to complete the point, I think in response partly to your concerns, if I can go to clause 10.1, where there's further reference to the licence. Tesco grants to TPF a licence to enter onto the Tesco premises, both with and without workman equipment, in a manner and at times agreed with Tesco, to enable TPM to install ATMs and thereafter to inspect, maintain, adjust, repair, alter, renew, and use the same. And then we find more provisions, again of the kind which, as the first-tier tribunal correctly acknowledged, are typical in any leasehold arrangement, never mind a license or a license agreement. They're typical regulations controlling how, in practice, to operate so that people aren't stepping on each other's toes. Clause 18.3 is perhaps worth noting. Unless this agreement otherwise provides, nothing in it creates a partnership or employment relationship between the parties or makes one party the agent of the other. Now, my lady, you may say, well, if what the parties create is an agency, that's what they've created, and it doesn't matter what label they put on it. But at least as far as the parties were concerned, the bank was not acting as agent for the shopkeeper. And they made that clear. Then there's the Sainsbury's Agreement. This is being given the label Squadron Agreement for reasons that elude me but aren't relevant. This is the most elaborate of the agreements. It starts at memory stick page 425. The main difference is that it incorporates provisions which provide for the store's staff to have hands-on, day-to-day involvement in the routine servicing and replenishment of the ATMs. But otherwise, it's substantially similar to agreements we've looked at, but I ought nevertheless to show you some key points. At page 437, (2.1), notwithstanding that the store, that is JS, may procure that a store occupier carries out certain of its obligations under this agreement, the store group, that is, shall remain liable to the bank under the terms of this agreement. Then the store group shall procure that where this agreement states that an occupier shall take a certain actional step, the store shall procure that each occupier does the same. And then it's worded in this way because it's an agreement at group level rather than individual store level. But at clause 3.1, subject to 3.2, during the term, the bank shall and the store shall permit and procure that each occupier shall permit the bank to, again you see, install and operate. Clause 4.1, subject to my lady's point about what this is directed to, there is the exclusivity provision in form similar to what we've already seen. There's machinery for, there's a detailed license at clause 5.1. Provision for installation and relocation at 6.1. And then in clause 8, we have reference to first line maintenance services. And this is where it crops in. You see that the store undertakes to do the job which Tesco subcontracted to third parties. But my submission is that in law, the effect of these obligations to maintain, which are undertaken by Sainsbury's staff, is exactly the same as if the bank had subcontracted to a third party. And the first tier tribunal instantly recognised that, so in fairness did the upper tribunal. The Court of Appeal drew no attention to it at all. Didn't analyse the contracts at all. And similarly, clause 9, the support services. Provision for licence fees, of course. In all these agreements, there's provision for the bank to make the payment to the store. It's a very unusual situation if the correct analysis is as the Court of Appeal has suggested. And there are elaborate provisions for termination and so on, dispute resolution. Clause 27 on page 459, no partnership or agency. Again, at least as far as the parties were concerned, the bank was not there as an agent for the shop. There was one other provision I wanted to show court, but I lost my note of where it is. One of the least of these agreements contains a helpful definition of ATM site. I'll have to come back to that rather than taking up time now. I'll make the point generically at this stage. As the court will appreciate even from that brief introduction to the contracts, it's relevant and necessary in relation to each of these contracts to be able to identify where is the ATM, because contractual obligations are going to apply in relation to the site of the ATM. Yet none of these agreements specifies in any detail how to demarcate that site. There may be provision controlling how you select it, but I'm going to be asking rhetorically the question, if that's good enough for contractual certainty, why isn't it also good enough for rating? If you don't need any particular level of detail to describe the site in order to know how the contract operates in relation to it, why should rating exact a more demanding standard? You know what is the site of the...
Because it's a different test.
You know what the site of the ATM is once it's up and running.
Yes, I mean, I'm not sure that the contract, I mean, you may be right, but the contract doesn't really help you. In the contract, all you need to know is what the ATM is you're trying to service. For rating, you need to have a clear, certain hereditament, which is, of course, maybe a quite different test.
I'm going to develop that in due course, naturally, but when one analyses how rating works and how it's developed, the concept of the hereditament is a byproduct. It's what you get. It's the result of a finding that there is occupation of a unit of land that meets the land criteria. That's what gives you the hereditament. You don't start off with the idea of a hereditament and from that work backwards. But I'll develop that in a moment. May I then make
The point, as I understand it, none of these agreements, as you say, actually specifies where the ATM machine is going to be.
That's right.
The important point is it imposes certain obligations in relation to the ATM wherever it's found.
Wherever it may be,
Yeah.
whether it's the store that selects the site or the bank that selects the site once it's...
Your point is once that's been done, then you have got something which is...
That's exactly it. It's the occupation of a defined space, defined once it is occupied, which matters in rating. That is the exclusively relevant consideration on that point. So may I then make some submissions on the back of those contracts? First of all, each contract confers on each bank a right of exclusive occupation of each ATM site for its purpose of operating each such site. Secondly, that purpose is not met...
Unless these are written down somewhere already. Are they in your case, or...?
I think you would find them in the case, but not in this form. I mean,
Right.
it's convenient to have them tabulated here.
Could you just repeat the first one again, please?
Each contract confers on each bank a right of exclusive occupation of each ATM site for its purpose of operating each such site. Secondly, that purpose is not met by any activity on the ATM site of the host store. Each ATM site is described contractually in simple form, but that's good enough for the contracts. It's the point I've just made. I won't repeat it. My next submission looks ahead to the argument of the respondents that the ATM site and the bank occupying it is in the nature of a lodger. Can I here make a submission that I'm going to be coming back to, but so I can flag it up now? The bank, in occupying the ATM site, is not receiving any retail service from the store. The bank is not present on the premises to receive any retail service of the host. Unlike the lodger, who is present in a hotel room only to receive accommodation from the hotelier. And not like the lawyer in court, even on a long trial, which is Mr. Kalinski's example, who leaves his boxes on an area of the courtroom floor. All the lawyer is doing is representing a client who is visiting the court in order to receive the court's service provided throughout the courtroom. All of that is completely unlike the situation of the bank in these cases, whose presence is not referable in any degree to receiving a service from the host on the ATM site.
No, but it contributes to the service provided by the bank, to the, by the store to the public.
Including that, yes, including that.
It contributes to that.
You can say that it contributes to that. My point is the distinction between that and the case of a visitor in a hotel is the bank is there not to receive that service offered by the host. It's a completely different thing.
I noticed in one of the contracts that there was a minimum performance level,
Yes.
so that the bank could say, we're taking this away if their turnover fell below a certain point. So to that extent, they are dependent on the store's activity.
Oh, but, lady, it's not uncommon in leases to find that, for example, the rent is payable by reference to such considerations, or indeed that rights of termination arise if the business doesn't operate as well as one had hoped it would. But the question has always got to be, my lady, one has to come back to the question, why should that make any difference? Why should it make a difference? One of my criticisms is that in Clydesdale and other cases, the courts have identified lots of factual differences, but not always asked, well, why should this factual difference produce any legal consequences? Once you have identified what rating does at a fundamental level, which is to tax occupiers of land, why should the various distinctions which might be drawn have any legal consequences? That it's necessary to audit such distinctions against that kind of question. And indeed, finally, and perhaps most tellingly, when the court reflects on whether the Court of Appeal's approach is sustainable, the Valuation Tribunal for England conducted a correct analysis of the contractual machinery at pages 350 to 355. Let me just check that I'm giving you the memory stick references rather than the... Yes, memory stick 350 to 355. And concluded correctly that the effect of these agreements was to confer on each bank a right to occupy the site of each ATM exclusively for its purposes.
So where's that?
It's pages 350 to 355. Paragraph 78 is one of the main paragraphs. This is at page 354. There's a degree of reciprocity between the operator and host store in the agreement, according to the appellants, which affects control of the ATM. I do not see how that affects paramount control. Frequently, leases will place obligations on both parties. I have no doubt that a tenant in an undercover shopping centre has a number of obligations in the lease, as will the landlord. None of those mean that the tenant is not in occupation. Whilst there's no lease in these appeals, the same principle holds water. None of what is mentioned affects the operator's enjoyment of the ATM site. In fact, if anything, they enhance it. Goes on to consider transients. In the upper tribunal, the first appeal happened. May I ask the court to look quickly, please, at page 151 on page 312.
The page number is 312, is it?
Memory stick 312.
Thank you.
And it's the second part of this paragraph that's relevant on this point. We're satisfied that the physical characteristics of a site, rather than incidental details of access or servicing arrangements, justify treating it as a potential hereditament, inevitably borderline cases. But it was concluding, having looked at the contractual provisions and set them out earlier, that they didn't relevantly detract from its conclusions. Then at paragraph 177, there's reference again to the restrictions and so on towards the end. The restrictions in place should therefore be seen as facilitating the bank's enjoyment of the site rather than interfering with it. That's the last sentence. And paragraph 178 also includes reasoning which can be tied back to the contracts and which reaches the same conclusion in the last sentence. For those reasons, we regard frontline servicing practices as subsidiary to the physical characteristics of the sites and the purpose of their occupation. In the Court of Appeal, as I've said, the contractual provisions are indicated at paragraph 6 through to 9 on page 249. But the court acknowledges that the tribunal, in paragraph 5, it says, provided a very full and clear account of the relevant facts, including the relevant practical and contractual arrangements. So I don't criticise the Court of Appeal for not setting out the terms of the contracts in as much detail as below, but I do have a respectful criticism to make arising from how it dealt with the contracts, because at paragraph 88 on memory stick page 274, it's said, does the court say about 3 lines down, that the retailer as owner had in all these cases, both internal and external ATMs, retained sufficient control of the site in contractual, physical and functional terms. That, if I may say so, is a proposition that calls for some analysis. If you're going to make that suggestion, one would expect there to be some reason that shows what about the things store's staff were doing were assertions of control by the store, rather than, as both the tribunals below have recognised, merely helping, and without being aspects of control.
To what extent is this a question of fact? I mean, remind me, is the upper tribunal a fact-finding body as well as the...
In strict legal theory, the right of appeal to the upper tribunal is the same as in any appeal case. But in practice...
Sorry, it's not purely law.
It's not pure... Well, it's like the Court of Appeal's jurisdiction.
Yes, but it's not. I mean,
it would ordinarily...
The general position in the upper tribunal is appeal is on law only, but the VTE was outside that regime, and I'm trying to remember what...
That's right. In practice, what happens in the upper tribunal is that it allows a rehearing to take place.
Yeah, but it's a broader discretion in the rating context than it is in, for example...
Yes, that is right.
Yeah.
I'm sorry, did you say it allows a new hearing to take place?
It allows evidence to be heard, to be received again. It's like a de novo hearing.
So this was a de novo hearing in the upper
Yes.
tribunal. But once you get to the Court of Appeal, of course, it's more limited.
It's more limited, yes, that's right. But so far as concerns my Lord's question about, I'm not sure if your Lordship had in mind also the question of the extent to which the matters raised are questions of fact.
Well, I was trying to understand, you were pointing to the fact that the Upper Tribunal and the Evaluation Tribunal reach, you say, the same view about the nature of these arrangements. I'm not sure whether you're saying that the Court of Appeal impermissibly interfered with their findings of fact.
No, I can't say that, because my contention is that the issue of rateable occupation is one of law. You have to identify the facts accurately, and in that sense it's a factual question. It depends on the facts.
Yeah, well, I think in paragraph 88, the Court of Appeal accepted the facts that the tribunal had accepted, but it then went on to say what the correct answer from those facts should be.
Look, I think that may be the right way to read it. My complaint is that if you're going to do that, it would be helpful to know what are the reasons, what are the bits of the contract which are said to manifest control.
Yes, well, I'm sure it would be helpful, but does that, the fact that those are not articulated by the Court of Appeal, does that vitiate their decision?
It may do, my Lord. It means that your Lordships can't give as much weight to it as might have been the case if there had been good reasons. But as it stands, that's just an unreasoned assertion.
Am I right in thinking that the bank always had ultimate control? The bank had control of the machine, but the store had control of the decision-making process as to where that machine should be located?
Not in every case. I think there are examples where there was a participatory process where the input of the bank was required, where the bank had a role in selecting locations. It's not universally the case. I think, in fact, the Cardtronics example agreement is an example of this, where the bank had the right to choose the location in the store, subject to a limited right of refusal by the shop owner.
That is the exception, is it?
No, I think that also in the case of co-op, there are quite, from memory, there is machinery which regulates how the site should be selected. Let's see. Page 527, for example, the ATM shall be installed at the society's premises in a prominent location by mutual agreement. It's a collaborative. It's basically a collaborative process.
But I mean, for your argument, that doesn't matter.
It doesn't matter at all. No.
Once it's been selected, whoever buys, then it becomes fair and different.
That's exactly it. So I'm sorry, I've taken more time over the facts than I thought was likely. But I now need to, unless there are further questions arising from the facts and the contracts, which would be helpful to address at this stage, I wanted to offer the Court a bird's-eye view of the central problem in this case, please. What about the Court of Appeal's approach creates a problem in rating? Because after all, if you adopt the perspective of the shopkeeper, it doesn't seem obviously wrong to say, take the Cardtronics case as an example, it doesn't seem obviously wrong to say, well, that is just a part of my shop, indistinguishable from any other part of my shop. It doesn't seem obviously wrong from that perspective. And you can sympathise with that viewpoint. It may even be the gut reaction that most people would have looking at these facts. Similarly, in that case of Mazars, it's not unnatural for a firm of accountants to think it's got one office, even though its office in fact has two floors, one on the first floor and one on the sixth floor of the same building. It's not unnatural for the office operator to think, I've just got an office. From that perspective, it's intelligible. The question for this court, as in every such case, is that the right perspective? And as in Mazars, I will show you through authority in due course, but let me now make clear my position. It turns out that that is the wrong perspective. The correct perspective emerges when one recalls that rates are a tax on the occupation of land, not in any loose sense, but in the sense that each occupier of each unit of land must pay the tax. In a way, that is the beginning and end of this case. Once you appreciate that, the rest follows. You can't make differences based on the size of the occupation. You can't make differences based on how it is defined, what evidence you need in order to define it, whether you need to look outside the hereditament or the fact of occupation. You can't take a decision based on how the parties think about it themselves, because if you do, you may find you are not capturing all occupiers, and you're thus creating an exemption from rates without statutory authority. We've illustrated this in our printed case with one example, Bank A and Bank B. But I'd like to offer one or two more examples, which will bring this point out, I think, even more clearly.
Remind me where that is.
Paragraph 3 is the main paragraph. I posit the example of an ATM situated, I've given the example of a house on the high street. Maybe it would have been better to say on the external wall of an office. That might have been a better example. But you imagine a high street where there's an office building, there's an ATM on the external wall. No synergy in that case. Why wouldn't rates be payable in respect of that ATM on the Court of Appeals approach? Next door, or 3 or 4 doors down, is an ATM identical in every respect, under exactly analogous arrangements, but behind it is a shop. On the Court of Appeals approach, the ATM in front of the shop isn't rateable. How do you explain that to the bank in occupation of the ATM in the office? You can't. You cannot do it. The point becomes even more in focus with a couple of other examples. I'd like you to picture an ATM in a unit on the high street. It's going to turn into a Sainsbury's store, for example. Sainsbury's have started work on it, and they've got as far as putting in the ATM in conjunction with a bank. The ATM is up and running. A skeleton staff is provided to enable that to happen. But something happens, and the store itself isn't open for retail trade for some time. What is the status of the ATM while the shop is not trading? There's no joint purpose being served in that situation. Take the next example of a case where the store eventually starts to trade and trades for some years. On the Court of Appeals approach, there's a shared purpose, no hereditament. But the shop then ceases to trade, but the ATM continues. What then? My third example is this. What if the store stops trading because it's turned into a data center or an estate agency? Same ATM, same practical arrangements. In all these cases, my lords and my lady, the experience of the bank in its occupation of the ATM site is identical. What's changed? What's changed is the characteristics of the person who occupies another unit of land. How, in point of logic, can that be relevant? Now, that, you may think, perhaps is a series of questions that arises in external hole-in-the-wall ATMs. What about the internal ones? Well, it's true that it's harder to imagine the examples I've given ever cropping up in the case of internal ATMs. I would accept that. But nevertheless, one has to squeeze a bit and think through what difference it actually makes if the ATM is on the inside of the building. What is the difference? The difference is that you have excluded customers who don't enter the shop. How is that different from a cafe in an airport, where the only people who can use it are passengers about to take off who've just landed? How is that different from the cafe in the basement of this court, where the only people who can use it are visitors to the court? How is it different from the kiosks in in Southern Railway, which could only be used by visitors to the station? Correctly analysed, the operator in each case has, through its own volition, opted to trade under those restrictions. That doesn't affect the quality of its occupation in any way that's relevant to rating, because it is nonetheless his business, whether or not he does more or less trade, because he's inside rather than outside. There's one more example I'd like to give, if you can tolerate it, which is to flush out another part of the case and some distinctions that are relied on by the respondents. Let's take just slightly different facts, but we can perhaps imagine in Oxford Street this is quite common. You have currency exchanges, where there's a person behind a glass screen exchanging currency and providing that sort of transaction. And there are quite a lot of them. I'd like you to imagine that there is one on each side of the street. And in one of them, the owner of the business modernizes. The way the owner of the business modernizes is to put in a robot instead of the person behind the glass screen, so that it works a bit like an ATM. What has changed? Technology in that situation has got rid of the person. It has shrunk the volume of space that the business needs to occupy. Why is that relevant? Nevertheless, the business is occupying a unit of land. How then would you explain to the owner of the business that had not modernized why he should continue to pay rates, but his neighbour on the other side of the road shouldn't? Just because of changes in technology which enable the robot to do the work of the human in a smaller volume of space than the human would have needed. Now, these are the problems in rating.
I'm not sure I understand that example, because, I mean, in each case it continues to be a separate unit or hereditament. It's not, we don't have the question of whether it's part of a store or that relationship.
That example is directed to the question whether it makes any difference that there's a chattel rather than a person doing the job. That it's not directly.
Is that part of the case?
It's that part of the case, yeah.
I wasn't aware that that was part of the
It does seem to be part of the case. It seems to be part of the case that occupation by a chattel is problematic.
I see, okay.
Could you help me with this? As I understand it, the case put against you is that the store hasn't surrendered occupation of the space. There's a shared occupation because the bank derives a benefit from it, but so does the store. And under these arrangements, seen as a whole, the store has never actually parted with a possession, or at least all the possessory rights in relation to the space occupied by the machine.
Yes, it's an interesting argument, but at its root, the problem with it, in the way your lordship posed the question, actually reveals this, is that the sense in which the store is said to have retained control is that there is a common purpose between the host and the occupier. And that's using purpose in a particular way. It's using purpose to describe why the transaction was entered into. It explains why the host let the bank into occupation. It's looking at it from the perspective of the parties, of the shopkeeper and of the bank. It's not wrong as a matter of language to say we have this common purpose. But in rating, that's not the kind of purpose that's relevant. The question in rating is not why was the transaction entered into? It's what rights does the occupier have under the agreement? And if you focus on that question, those indicia, so-called indicia of control, disappear. They're not present anymore. And this is the point of law that emerges from the authorities, which I'm going to have to show you in due course. The kind of purpose that the Court of Appeal has had regard to is not the right one. If you uphold the shared purpose basis of decision, then it's going to be difficult to explain to Bank A, in my example in the printed case, why it should continue to pay rates. Just because in the shop next door there's a shared purpose between the bank and the store. If you allow Cardtronics' sort of unit point, that there's no geographical unit, it's going to be difficult to explain to the unmodernized currency exchange why it should continue to pay rates while its neighbour shouldn't. And if you uphold the movability point, it's going to be difficult to explain the sheds in Kennet, which we'll look at, and the bookcases and so on in Southern Railway. The choice ultimately for this court is between rates as a tax that is unpopular but consistent and rates as a tax which is unpopular and capricious. That ultimately is going to be the choice. Can I then turn to the statutory framework, please? The 1988 Act is in tab 2 of the main authorities volume. Page 973, section 42 of the Local Government Finance Act 1988.
Sorry, could you give me the page again, please?
973, my lord. It tells you what the list has to contain. For each day it's in force, it has to show each hereditament which fulfills the conditions listed. Section 43 imposes the tax liability. The person, the ratepayer, shall, as regards a hereditament, be subject to a non-domestic rate in respect of a chargeable financial year if the following conditions are fulfilled in respect of any day in the year: on the day the ratepayer is in occupation of all or part of the hereditament, and the hereditament is shown for the day in a local non-domestic rating list in force for the year. The very simple point to make on the back of that provision, my lord, is that it doesn't matter that the hereditament wasn't shown in the list on the day before the occupation commenced. That's just not relevant. So there's nothing in the framework of the Act to suggest that the hereditament must pre-exist the occupation.
I'll tell you, so you say we read section 42 on the footing that a hereditament cannot exist unless it is occupied. Is that what you're saying?
My lord, no, that a hereditament, it's not a necessary feature of a hereditament that it pre-exists occupation. It's not a necessary ingredient that you have to be able to identify the hereditament separately from the occupation.
Yes, but my Lord's question is occupation a prerequisite for the existence of a hereditament?
It's the way it works is that historically we can see this when we trace through the origin of rating. The Statute of Elizabeth imposed an obligation on the occupiers of lands to pay the tax. That is the obligation. In the 19th century, it was found necessary to introduce lists of hereditaments. Before then, there hadn't been lists. Hereditament is the label given to the unit of occupation in respect of which the tax is paid. It is just a label.
Yes, but it's a label with some significance.
Certainly it is.
It means that to be a hereditament, there must be occupation.
Oh, certainly.
Yeah.
Certainly, in its original form. My Lord, the only problem arises because in the 20th century, Parliament introduced the concept of unoccupied rates. And there is therefore a dislocation between, if I can call it this, classical rating, where you really can't have a hereditament without the occupation, and modern rating, this bolt-on form, which recognises that an owner might be responsible to pay rates in respect of property even though it's unoccupied.
But that doesn't arise in this case.
Doesn't arise in this case, that's exactly it.
But in this case, you accept that for the ATM to constitute a hereditament separate from the store, it has to be occupied.
I not only accept it, I assert it.
Yeah, but by someone other than the store owner.
It has to be occupied by the bank, yes. Mm-hmm. The contractual arrangements have to show that the bank has rights to use it for its own exclusive purposes. I accept that. That's part of my case.
Yeah.
So I mean, the usual case is that you can have, for example, a shop which may be occupied or it may be unoccupied, but in either situation, it's entered on it appears on the list. But you're saying that in the case of a case of an ATM site, it only goes in the list if it is actually occupied.
Yes, there's nothing surprising about that. You can imagine a field, an empty field, which has the potential to be all sorts of things. If somebody goes on to the field and puts up a tent for long enough and occupies it for business purposes, a hereditament comes into existence. It's a point of no consequence that prior to that moment there was nothing to show either on the ground where the tent would be put or in the list where it might be put. It's a point of absolute immateriality. And my only point on section 43 was that the statute makes this absolutely clear. You only need to know what the hereditament is once you've found there is occupation. You don't need to know before that moment arises.
No, but it's identifiable only by reference to its occupation.
Yes, what's the issue? It makes
No
no difference.
it's a very peculiar kind of hereditament if it can only be identified by reference to occupation.
Well, take the case then that I've given in my printed case of, again, I'm asking the court to imagine a high street, and you've got a row of shops. But the row of shops is interrupted by an open space, which might be used as, let's say, a mechanic's yard. It's a mechanic's yard. But it's surrounded by walls, because it's surrounded by buildings. There's a building on the left, a building on the right, and a building behind. But now suppose that a developer buys all three of those buildings. And the developer knocks them down. The walls are gone. Does that mean that the mechanic's yard is no longer a hereditament? It's defined only by its use.
Why isn't it defined by being able to be drawn on a plan?
Well, it can be defined. That is certainly an important testimony. You can't have a hereditament unless you can draw it by a line on the plan. What's the problem in drawing a line on the plan in relation to an ATM? There's absolutely no problem. And in fact, the witnesses in evidence who are asked about this accept it. You could easily draw a line on a plan to describe the site of an ATM.
Except it would be moving on the movable ones, so they may be in a different category.
If they wouldn't actually be movable. I don't want to get at this stage involved.
No, don't let me take you off your track.
No, there is no difficulty in identifying the location of an ATM site. If you wanted to depict it not only in 2 dimensions, with a square on the plan, there'd be no difficulty in depicting it in 3 dimensions either. It is an integrated box. It's not quite a box, it's got a bulge in it and so on, but it is just a cabinet. There is no difficulty whatsoever in meeting the geographical test.
So,
All the courts below have accepted that.
on your argument, if for example, Sainsbury's decided to allow Sainsbury's Ice Creams Limited to locate a freezer cabinet in one of their stores to hold ice creams for sale to the public, that would bring into being a separate hereditament occupied by Sainsbury's Ice Creams Limited.
Potentially, depending on the contractual arrangements, it would. But, my lord, my whole point is rating is not afraid of that, and neither should it be. Mr. Kalinsky raises this spectre. He gives it the buzzword atomization. He posits the example of Oyster cards. He says how crazy it is if you can have a situation where potentially an Oyster card reader is a separate hereditament. But why? What is crazy about it? What's driving that situation is changes in technology, which mean that there are new and efficient ways of using smaller and smaller parcels of land, ways in which different businesses, independent businesses, can use smaller and smaller parcels of land. It's not rating that's driving that process. It's driven by business. Rating keeps up. But to let rating keep up, we have to apply consistent principle. That's why rating didn't balk at assessing fibres as thin as a human hair in Vitesse. Rating keeps up, but it is not driving these changes.
We'll be looking at that case, but otherwise your best case seems to be the ones about bookstores
Bookcases.
100 years ago, and you seem to be making quite a big jump. I mean, you may be right, but it seems, but the implications of saying that any item of plant or any can create a separate hereditament, however small, does seem quite far-reaching.
It does indeed. It certainly does. And Parliament is aware of this. I can show you next the provision which deals with it. It's in section 64. Section 64.1 is the definition which has been criticised for its circularity of what a hereditament is. My lords, this is at page, and my lady, this is at page 985, memory stick. It takes you back into, ultimately, what the courts have said a hereditament means. So we don't learn very much from section 64.1. But section 64.3 is of importance. The Secretary of State may make regulations providing that in prescribed cases, anything which would, apart from the regulations, be one hereditament should be treated as more than one, and anything which would, apart from the regulations, be more than one should be treated as one. If it gets out of hand, the Secretary of State steps in. And the regulations we have produced and asked to be handed up earlier are an example of this. The factual situation which has arisen is that telecoms operators put up masts, and onto the masts go pieces of a mixture of equipment, a mixture of rateable equipment, which is treated as if it was part of the land, and non-rateable equipment, like antennas and receivers and transmitters, which are just chattels. Each time, a new chattel is added to the mast, a problem arises. Who operates the chattel for the transmission? Is it EE or BT or Orange or whoever the operator is? Because potentially with each separate occupation of a few square inches on a mast, there is a separate hereditament. Clearly a problem, a practical problem. So Parliament intervened. It has simplified the process. It has said, Regulation 3, this paragraph applies to telecommunications apparatus other than accepted apparatus which is attached to, or situated in or on a telecommunications hereditament, and so occupied or owned as to constitute, apart from this regulation, one or more hereditaments separate from the principal hereditament, telecoms apparatus to which paragraph 1 applies, and the hereditament which is the principal hereditament in relation to such apparatus shall, subject to 3, be treated as a single hereditament in the occupation or ownership of the host. And when one reads through the definitions to make sense of that, we find that the effect of it is that the person who owns the mast or has the right to let people use it is treated as the occupier of a single hereditament. So Parliament is perfectly relaxed about the potential for atomisation. It's absolutely relaxed about it. It has the tools to deal with it. What's not sustainable is for the court to intervene on an ad hoc basis, based on an impressionistic sense that what it's looking at doesn't feel like it should be a hereditament, because it doesn't correspond with old-fashioned uses of land. I don't have to show that there is a precedent in the books for my use of land, for this particular use of land. Rating applies generally. There are also provisions in the Act relating to valuation which crop up in connection with Mr. Kalinski's argument about what, if any, is the significance of the fact that the ATM machines are chattels which don't fall to be treated as part of the land under the plant and machineries regulations. The only real point on that is that the plant and machinery regulations are made under a power limited to stipulating valuation consequences. In other words, not relevant to the questions that arise in this case. We see that, for example, from pages 991 and 992 in the memory stick. At paragraph 2, if you could read over the page to 2.8 on 992, the Secretary of State may make regulations providing that in applying the preceding provisions of this paragraph in relation to a hereditament of a prescribed class, prescribed assumptions as to the hereditament or otherwise is to be made. The preceding provisions are entirely to do with valuation. There is no power or any power exercised by the Secretary of State under the plant and machinery regulations is limited necessarily to valuation matters. The plant and machinery regulations themselves are in the bundle starting at memory stick page 1001. They were reviewed by Lord Carnwath and this court in a case called Iceland recently, which is also in the bundle. But your Lordship see from the recital on page 1001 that the rule-making power invoked is the one I've just shown you. They're just about valuation. They have nothing to say of any interest about this case, and that is what all the courts below have held.
I mean, the whole purpose of these regulations we saw in Iceland is to distinguish between what's called process machinery, or the tools of the trade,
exactly.
and machinery or plant which is already part of the building or hereditament.
Exactly.
But here it's accepted, and indeed effective the regulations, that these ATM machines are tools of the trade.
Yeah, absolutely.
Can I just, going back to this telecommunications example, is there any background to this? I mean, was there a case which sort of highlighted this problem?
I can look into that. I'm not aware of any authority that highlighted the problem.
I mean what you're saying is that the sort of the individual antenna, or whatever it is, which is operated by BT or someone, is itself not relevant for valuation purposes if it's covered by the plant and machinery order, but the little thing that links it to the mast is a hereditament.
It's not quite that. The orange is a case in the bundle which exemplifies some of the problems which arise in this area. The mast is rateable.
Yes.
The land on which...
But that is occupied by whoever is running the mast.
It's occupied by the mast. The mast itself counts as land because it's named in the plant and machinery regulations. Many of the cables are also rateable because they are named in the plant and machinery regulations. But the operative bits, the bits that make the whole network operate, are the antennae, the receivers, the transmitters. They are not named in the regulations. They're just chattels. But nevertheless, the regulations proceed on the footing that they might, when they're attached to the mast, amount to occupations creating hereditaments.
But what's occupied then is just a little sort of square inch of the
It would be
mast.
more than a square inch. These antennae are typically, a metre or, I don't want to give the dimensions. It's not as, they're small. They are small.
But that square metre, whatever it is would be the hypothetical hereditament.
It wouldn't be part of it, no.
It would be it.
The rent, but the site which it occupies is capable of being a hereditament. In the same way that the site occupied by the bookcases in Southern Railway was capable of being a hereditament. I mean, my lord, your lordship is right to say that in the authorities the best example is the bookcases in Southern Railway. And one of the questions all along to ask is, well, what really is the difference between what we're looking at here? What is the relevant difference? Lord, if you wanted an example of an authority where the telecoms crops up, it's orange in Bradford, it is in the bundle.
What's the page then?
I said that, I just put it away.
1179, I think.
I'm sorry, I haven't got a flag in mine.
1180.
Thank you very much, my lord. Yes, and it's Lord Justice Thomas. Paragraph 1 has the. Well, I'm not sure it's necessary to take up time going through it at least at this stage. But there's a description of the facts at paragraph 9. Hereditament was located on the grass verge, a publicly maintained highway. It comprised a piece of land on which there had been erected a hollow mast, 11.5 metres high, with telecoms aerials and a steel cabinet. Standing on a concrete base, the aerials and equipment were not rateable. So it's not exactly this, it's not the same problem. It's touched on by the regulations later, but this is just an example of how, if you like, modern uses of land are dealt with by rating without any difficulty. Can I then turn to the authorities that I would like to show the court? I'm going to limit myself to the smallest possible number. I do need to show you some absolutely seminal cases, because the basic reasoning in them is incompatible, profoundly incompatible with the approach that we find in the Court of Appeal's decision and the upper tribunal's decision to a lesser extent. The first is the case of Poplar, which is in tab 37, memory stick 1634. The problem which arose in Poplar is that there was effectively a Rent Restriction Act which fixed the maximum rent that a landlord could have for premises. These were in the days when residential premises were rated as well. And the tenant said, well, the rates should be fixed by reference to the maximum rent stipulated by the rent control provisions. And the House of Lords said, no, that's not at all the case. Rating works independently of the value of the property to the owner. Rating focuses on the value of his occupation to the occupier. So that's what we find happening in Poplar. The reasoning is extensive and careful. Lord Buckmaster gave the first speech starting at page 101 internally, otherwise memory stick 1642. I'd like to take it up. I mean, I'm not discouraging the court from reading all of this. In fact, if your lordships can bear to and have the time, you would find it instructive to consider the whole of this report. But at page 104, about 6 lines down, I wish to draw attention to the way Lord Buckmaster rooted his answer to this question in the fundamental characteristics of rating. From the earliest time, it is the inhabitant who has to be taxed. It is in respect of his occupation that the rate is levied. And the standard in the Act is nothing but a means of finding out what the value of that occupation is for the purposes of assessment. In my opinion, the tenant might reasonably be expected to pay as the rent which, apart from all conditions affecting or limiting its receipt in the hands of the landlord, would be regarded as a reasonable rent for the tenant, who occupied under the conditions which the Statute of 1869 imposed. The Statute of 1869 is the rating statute, not the rent restriction statute. Then moving down the page, there's a reference towards the bottom to the King against Monday. The officials of a charitable foundation in actual occupation of an almshouse were all held to be rateable, although again the almshouse could not have been let under the terms of the trust. Again, it was the actual beneficial occupation that was the subject of the rating, and the question as to what rent the actual landlord was capable of exacting didn't enter into the calculation. The court can see the focus here on the experience of the occupier in his occupation of the land. It's fundamental, absolutely fundamental. Lord Atkinson at page 107, on the first main paragraph in the page, said this: what the ratepayer is, under both the Act of 1836 and that of 1869, rated in respect of, is decided by many cases in this House to be the beneficial occupation of a hereditamент. And if he is in enjoyment of this species of occupation, he must be rated, even though he should not be a tenant of the hereditamент, and though no person could be made the tenant of it, and though no rent is or could be received in respect of it. At page 109, towards the middle of the page, there's a sentence beginning results. Results such as these seem to show, does the court have those words? Results such as these seem to show that it was never designed to supersede by this Act the old system of rating dwelling houses. Again, it cannot be, I think, be disputed that equality of rating is and should be one of the main objects of all rating systems. again at page 112, towards the foot of the page, Mr. Talbot, on behalf of the appellant, cited several cases, in argument referred to as charity cases, to show that the principles embodied in these rating acts were in fact applied to the rating of hereditaments long before the passing of that act. They are interesting and instructive. He then turns to the example of the King against Cat. If one reads down and scans, I take it up from about a third of the way down the next page, memory stick 1654. They were held to be rateable under the 43rd of Elizabeth, which provided that the rate should be imposed upon any occupation of land, because they were in beneficial occupation of the aforesaid premises and were therefore within the statute. Again, all rooted in fundamental rating principle. It flows from the characterization of rates as a tax on the occupation of land. Reading on, the last of these cases was the King against Green. Their persons who are objects of a charitable foundation were in actual occupation of the almshouses, paying no rent for the same and removable at the pleasure of the patron of the charity. Again, my Lord Carr's concern about whether a person who can be kicked out at a moment's notice must pay rates. Clearly they must. They were held to be rateable. Mr. Justice Bailey said, if they are occupiers of property from which they derive a benefit, they are rateable.
I mean, you're slightly over-egging this, aren't you?
I'm sorry if I may.
No, I mean, as you say, it's a point which has been well established for many, many years, and
I do.
doubt it will be questioned as such.
Can I just then show you one or two other extracts? I'll take it more shortly. I don't want to over-egg it, but on the other hand, it is important. I'm not sure that the Court of Appeal certainly appreciated the extent to which its approach involves a departure from these very fundamental principles.
But it will show us in due course where they went wrong.
Right. But page 116, just to remind the Court, halfway through the page, there's a sentence where the words begin, rating is a process. And some of these points get overlooked as time passes, but rating is a process, we're now in the speech of Lord Sumner, between an occupier and a rating authority, to the determination of which the landlord and the lessee are strangers. That's an important insight when one reflects on how the Court of Appeal has approached this case, focusing on the business needs of the actual landlord and the business needs of the actual tenant, rather than on the process of working out for rating purposes who is the beneficial occupier of the ATM site. It's an important insight. Lord Parmore at 118 again draws the distinction between occupier and owner, emphasising that it's at the top of the page, 1659 in the memory stick. Fundamental principles permeate the whole system of our rating law. Rates are to be levied upon every occupier of lands. And there is further reference, which I rely on page 119. It's long been recognised in the second paragraph as a matter of principle in rating law that to make actual rentals the basis of rateable value would contravene the fundamental principle of equality, both between the rate contributions from individual ratepayers and between the totals, the rate contributions levied in different contributory rating areas. In effect, the result would be to make the amount on which the occupier of property is liable to pay rates dependent in many cases on the contractual relationship between a particular landlord and tenant, whereas it is dependent in all cases on a statutory direction applicable on the same principle to all hereditaments and intended to ensure equality of treatment as between the occupiers of rateable property and the rating authority. So I'm going to stop adding eggs to the pudding at that point based on that authority. The consistent theme present from in this case and in all the leading cases is the principle of equality or uniformity. Questions of rating arise between the rating authority and the occupier, not between the actual business needs of an actual occupier and an actual landlord. And all of this flows from recognising the fundamental character of rates as a tax on occupation. Then Southern Railway. This is at tab 21. I think I'm going to have to ask the court to make some time to read this in its entirety if it hasn't already. The judgments are long, both the judgment of Lord Russell and Lord Wright, but it's very difficult to skip over any part of the reasoning and do justice to it. In fact, one of the problems we see in Clydesdale is that important details of the reasoning in this case are overlooked. They're just not...
Are you saying there's differences between them, or are they all saying the same thing?
I beg your pardon?
Are you saying that there are differences between the three speeches?
No, my lord, it's not that they produce differences in substance, but in fact it's rather the opposite point that I seek to make. It's because both Lord Russell and Lord Wright are saying what in substance is the same thing, that one can't safely take the sort of conclusion that was drawn in Clydesdale based on what Lord Russell said without testing it against what Lord Wright said. It's not... Anyway.
Right.
The kinds of hereditament which are under consideration in Smiths are set out. As my Lord Carnwath pointed out, the most salient for our purposes are the book, the showcases, the stalls. But it's important also to have in mind the detail, I'm afraid, because the detail of the contractual arrangements is in point of detail not distinguishable from the agreements I've shown the court. You can see the agreements set out at page 1288 through to 516 and continuing in fact to 517. I'm sorry, I'm mixing up references to internal and memory stick numbers. My submission on the terms of the agreements is they are not distinguishable from the agreements in our case. And that this point seems not to have been appreciated in the later cases. I also want to call attention, in view of the way the Court of Appeal has proceeded and the arguments of the respondents proceed, to one of the arguments that was advanced on behalf of the Southern Railway Company. Lest it be said that no point was taken about the complementarity or the synergy of uses, that would be an oversimplification. If you go to page 1298, you see recorded on behalf of the Southern Railway Company submission that the supply of newspapers and books may be a subsidiary or ancillary undertaking of the company. And they were making that point in order to show that the bookstalls, kiosks, and other hereditaments were occupied for the purposes of the railway company. So there is a reference to complementarity, what the Court of Appeal now calls synergy. It was part of the case. The speech everyone, of course, is familiar with, most familiar with, is that of Lord Russell. The critical reasoning starts at page 1304, internal 529. But there is an important part of this paragraph which is sometimes left out of judgments which quote from it. I'm guilty of this in my own printed case. The important part which is sometimes left out are the words which at first glance look as if they are inessential introductory matters. He starts off by saying, in the next place, I would make a few general observations upon rateable occupation. But in fact, what he next says is the foundation for the test he later puts forward. He says, subject to special enactments, people are rated as occupiers of land. land being understood as including not only the surface of the earth, but all strata above or below, the occupier, not the land, is rateable, but the occupier is rateable in respect of the land which he occupies. He's doing just what was done in Poplar. He's going back to first principle. What is rating for? Occupation is not synonymous with legal possession. The owner of an empty house has the legal possession, but he's not in rateable occupation. Rateable occupation, however, must include actual possession, and it must have some degree of permanence. A mere temporary holding of land will not constitute rateable occupation. And then he says, he starts on the passage which is usually quoted. Where there is no rival claimant to the occupancy, no difficulty can arise. But in certain cases, there may be a rival occupancy in some person who to some extent may have occupancy rights over the premises. The question in every such case must be one of fact, namely whose position in relation to occupation is paramount and whose position in relation to occupation is subordinate. But in my opinion, the question must be considered and answered in regard to the position and rights of the parties, in respect of the premises in question, and in regard to the purpose of the occupation of those premises. In other words, in the present case, the question must be not who is in paramount occupation of the station, within whose confines the premises in question are situate, but who is in paramount occupation of particular premises in question. Now, a problem has crept into the law because of the Lord Russell's use of the word rival claimant. When you read that passage, I suggest it's clear that Lord Russell is using the expression rival simply to describe the fact that there are two candidates for occupation, and it's the court who has to choose between them. But this has been misunderstood. It starts, and it's most explicit in Clydesdale. Rival has been taken to mean business rival. And starting with, I will show you in a moment. From that proposition, the tribunal in Clydesdale was able to find a way of not following what it called the conventional Southern Railway approach. It said, in a case where there is no rivalry, but where the uses are complementary, you don't apply the conventional control test. Now, in later cases, there has been movement away from that reasoning in point of form. However, what hasn't been noticed is that it is only this idea, this mistaken view about what Lord Russell said, which opened the door to looking at the purpose of occupation otherwise than by asking the question about control.
But I mean, there's no suggestion that these were rivals in this case.
No.
The kiosk owners and the...
It would have been impossible to suggest that. They were clearly complementary uses, just as in our case.
But they're also candidates, as you have put it, for the instance of rating.
Yeah, right. And they were for reasons that are indistinguishable from those which are present in our case. In particular...
But is the use of rival by later authority not in these circumstances irrelevant to the present case?
It certainly should be.
Yeah.
But I'm seeking to explain the problem which has cropped up in the law and how it's cropped up.
Have I correctly understood your submission that the stores in each case are not in occupation at all of the part of the premises which is occupied by the ATM?
Yes.
You say the occupation is solely that of the bank?
Yes. For rating purposes. The way I wish to qualify that is that as a matter of property law, it may or may not be the case that what a landlord and tenant lawyer would call exclusive possession has been given up. It may or may not be the case. Whether or not that is the case, the occupation of the bank is exclusive for its purposes, and that is the test in rating.
And that, you say, is the same as in the bookstall?
Exactly the same as in the bookstores. It's not distinguishable. there's consideration of the lodger, detailed consideration at page 530. Perhaps I can, to save having to listen to me drone on, perhaps I can ask the court to read page 530 to itself. The submission I make on the back, particularly of the reasoning in the bottom half of that page, is that the distinction being made by Lord Russell is between a hotel guest who's present in order to receive the service of accommodation provided by the hotelier throughout the hotel, including the bedroom, and the case of, on his facts, the book case, the bookstall, which is not present on the station to receive any transport service. That is the point he's making. And likewise here, the banks are not present in these shops in order to receive any shop or retail service. That's why they're not that's why they are not like lodgers. It's worth just looking at one of the examples that Lord Russell draws attention to of cases where the landlord control principle has been applied otherwise than to lodgers. I've chosen Allen and Liverpool. Can I take us away from Southern Railway for a moment, perhaps metaphorically keeping a finger in at this page, but going to tab 24, which is in volume 2, and the report of that case of Allen and the overseers of Liverpool, just very quickly, if I may, to show you what the facts were at page 1388. In an example of a case where use of the dock by the shipper was not held to be sufficiently exclusive to mount to rateable occupation. At 1388, paragraphs 7 and 8, if your lordships and my lady wouldn't mind reading those paragraphs, you'll see instantly the distinctions. The correct characterization of that use was given by the court in the report at page 1394. Paragraph 15. All sailing vessels and steam vessels which come to the port at irregular intervals are loaded and discharged at berths provided with sheds of a similar description to those above mentioned, or of some other construction answering the same purpose. But the owners or agents of such vessels have no right to the preferential use of any berth or shed. So the correct characterization of the license in that case, which was held not to give rise to rateable occupation, was that it was a right of mere preferential use. That's a long way away from the book cases in Smith's and the ATMs here, where it's not merely a right of preferential use by the banks of an ATM site. There's nobody else that can use the ATM site while it's operating the ATM for its purposes, 1 million miles away from the landlord control principle as described there. Again, my invitation to the court is to consider the whole of this judgment, I fasten next, particularly on page 532, the paragraph that begins, "In truth." In truth, the effect of the alleged control on the question of rateable occupation must depend on the facts in every case, and in my opinion, in each case, the degree of the control must be examined and the examination must be directed to the extent to which its exercise would interfere with the enjoyment by the occupant of the premises in his possession for the purposes for which he occupies them, or would be inconsistent with his enjoyment of them to the substantial exclusion of all other persons. My Lord, in answer to Lord Kitchen's question about what is the occupation I say is present here, that is the description of the occupation I say the banks have of the ATM sites. And the focus is on the smallest unit of occupation. It has to be, for reasons Lord Russell has explained. Rating is about making sure that everyone who occupies land pays rates. That only works if you always look at the smallest unit. It doesn't work otherwise. Then there's consideration of the license agreements and reference to the old error about the need for some sort of property interest, emphasising that use is enough. You get that from the middle of page 533. And then there's a consideration of each point, each unit separately. He starts with everything apart from the bookstalls. And it's highly material to note the particulars of all of this reasoning, because he discounts all the sorts of objection to rateability which were relied on by the ratepayers in later cases with success in Clydesdale, wrongly with success. For example, going back to my Lord Carr's point, page 534, I cannot accede to the view that because the bank couldn't, without the consent of the railway company, get to the bank premises during a few hours in the middle of the night, in which no banker would normally desire to go to his bank, and throughout which hours the bank is in fact occupying the premises by means of its goods and furniture, therefore the paramount occupant of the bank premises is the railway company and the occupancy of the bank is a merely subordinate affair. Likewise here, the ATM site is occupied by the bank through its machine and through the cash in the machine which it owns. And the stationery which it owns. On the showcases, page 535 is Lord Russell's reasoning on this. There's a technical point under the Special Act of 1889 on which he differed from the rest of the court, but that's irrelevant. He says, apart from that point, do you have this at the bottom of page, near the bottom of 535, I would hold that the railway company was rateable in respect of the showcases, but only by reason of this special statutory provision. Otherwise, he would have said the showcases are in exactly the same position as the banks. Then he looked separately at the bookstalls. Again, a long description of the license, which I say discloses terms which are indistinguishable from the licenses in our case, and so far as one can tell, from the licenses in Clydesdale and the Bank of Ireland and Stringer. Indistinguishable. No less control being given to the banks in our cases than was given to W.H. Smith in Southern Rail. There's the court overturns, Lord Russell overturns an earlier case in which it had been held that Smiths were not rateable. And that's how he concludes his judgment. Lord Macmillan gave a shorter speech starting at page 538, 1313 in the memory stick. Lord Wright actually gave the fullest reasoning. He sets out the facts starting at page 542. Page 544, having, can I take it up specifically from the bottom of 543? The bookstalls used by smiths must be separately considered. Therefore, they differ in size, constructed of timber, cut and shaped by the company's workmen at their workshops, fitted and put together on the sites which they occupy in the station. They're of the construction familiar to all, considerable size, occupy their sites by their own weight, all being used on their present sites for some years without being moved, though it is said in evidence that it's possible to move them by mechanical devices. It's looking at movable structures. All these premises are in fact possessed and used by the various persons to whom they are let by the railway company for the purposes of their several trades or businesses. Then there's an examination of the agreements, and he looks not at why they were entered into. He doesn't ask what is the purpose of the occupation from that point of view. He asks, do my lords and my lady have this near the bottom of the page? What is their effect? Substantially, their effect is the same, so far as concerns what is material in this appeal. That is the question, whether there is or is not de facto occupation. He's not asking the question, why has the occupation been created? Does it serve the business needs of the host store as well as the subservient occupier? Doesn't enter into it. De facto occupation is what triggers rates for everybody. Uh, 546, he deals with the showcases, in the middle of the page. There, this meets one of my Lord Carnwath's questions. What if there isn't an agreement? The showcases are, in fact, such an example. The agreements for the showcases are in a different form. They're in form simply applications for permission to exhibit and maintain advertisements.
I mean, the showcases, were they described?
Yes, they are at
1288,
page
is it?
516 internally.
Or 513, you see what they were. Showcases containing goods exposed to the purpose of advertisement. 2 resting on the floor of the station. 1 connected with the walls by brackets. Is that right?
That's right, and their contractual, the agreement is
But I mean,
further.
what is the hereditament in those cases?
The hereditament was the space on which they were. The hereditament was the site of the bookcases.
So the one that's attached to the wall is simply a part of the wall.
Yes, I must admit, in my own impression of the case, the ones that were attached to the wall also stood on the floor. But I don't think that's a point of.
No, I mean, I'm just interested in a sense that's almost the most extreme example, because it's not like a bookstore with people doing things in it.
No.
Simple, and it's got, presumably it's just a case.
Yes.
Sitting on the.
Oh, absolutely. But in page 535, sorry, it's at line. I've gone back for this purpose to Lord Russell's speech, but it's an important point, a third of the way down. In my opinion, does the court have that? In my opinion, the sites occupied by the showcases fall within the general words.
So where was that?
It's
Page?
a third of the way down on page 535.
It is helpful to give the electronic number as well. I think
131.
I've got it now, it's 1310.
I apologise.
That's all right, don't worry.
But it's a third of the way down. The sites occupied by the showcases, that was the unit of assessment.
Did Lord Wright say the same thing?
I believe so. I mean, Lord Macmillan, first of all, deals with it at page 538. About a third of the way from the bottom, he says the land occupied by the showcases is accordingly not used for the exhibition of advertisements. That's what they were talking about. And then at page 1341, Lord Wright doesn't say anything specific about the sites. He concentrates on who occupied them, and he does that by reference to the question of the goods inside them. He does actually say, reading on, I think these showcases are occupied by their owners by means of the goods which they exhibit. A couple of lines up, but not otherwise occupied. The owner should be deemed to be in beneficial occupation of the land and should be rateable on it.
The hereditament doesn't have to have its feet on the ground, does it?
Absolutely.
So you could have the airspace that it's occupied being the hereditament.
You could. In fact, some of the 19th century cases about telegraph cables deal with exactly that point, and they note you can have, for example, a flying freehold would be rateable. That's absolutely right, my lady. Yes. There's another description. I'm sorry, I'm beginning to jump around a bit, but at page 534, otherwise 1318, Lord Wright further describes these showcases. Another class of premises are what have been called showcases. These are of small dimensions, exhibiting articles dealt with by the companies whose names they bear. They're built or placed against walls of the station, except one which is erected in a central space on the concourse. Necessary attachments are made for lighting. I think that completes the description in the report of the showcases. Returning to Lord Wright's speech at page 544, an examination of the agreements. Again, he takes each one in turn, and as summarised, the terms are indistinguishable from those in our case and in other ATM cases which haven't noticed the similarity. And the critical reasoning is probably that which starts at page 549 towards the foot of the page. In answer to my Lord Reed's question, you see right at the bottom of the page, dealing with this matter of when must a hereditament exist. Before they let them out, he's talking about the railway company, before they let them out, or if they do not let them out, the premises, or at least the site, are occupied by the railway company, and if occupied for purposes of the undertaking, form part of the railway.
Well, where are you reading from?
Sorry, no, this is the bottom of 1324, otherwise 549.
Last 3 lines.
Okay.
And then picking up about 6 lines down on page 550. So far, I'm referring merely to the site in the station. When the premises have been erected on the various sites, each becomes a new and separate hereditament, in respect of which the question has to be considered, whether as such it is ever occupied by the railway company at all, or if occupied by the company, is occupied for the purposes of the undertaking. It is the erection of a structure, as it was put here, the placing of a bookcase or a display case on the land, which creates in and of itself a separate hereditament. It's axiomatic, frankly. Lord Wright is emphatic that his approach and the approach of the House as a whole was based on well-established principles which it had sought to distill. If one sees this at the bottom of page 550, says it becomes necessary for the court to attempt a survey of the whole of the existing authorities in order to arrive at a consistent and comprehensive appreciation of the relevant law. This is why the judgments are so long.
Yes, but I mean, they've done it, so we don't need to go through it all over again.
Exactly. We shouldn't be reinventing the wheel about the lodger principle, for example. And all the premises were, of course, held to be in the rateable occupation of the sub-occupier. But, my lord, I'm sorry if I probably am over-egging the pudding. My point is that when one examines the detailed facts in this case and the detailed reasoning, rather than simply having the decision in mind as a matter of impression, when you get into the detail of it, it becomes hard, and I respectfully say impossible, to distinguish the ATM cases from the show cases and the book cases in Southern Railway. You can't do it once you go in detail through these judgments. You can only do it if you accept an impressionistic recollection of what the case decided. In other words, if you don't grapple with its basic reasoning. Page 560, beginning to draw things to an end, Lord Wright says, 1335.
Thank you.
I think that on principle their so let out is to be capable of separate assessment and ought to be excluded from the roll as not being railway heritage. He's talking about the kiosks, the Smith's kiosks, premises of considerable size, occupying definite areas which they have occupied for a long time without being moved. So much
Well, those are the bookstores.
Yes, the Smith stores. So much for the movability point. It is true that the railway company reserve power to change the sites, but the evidence is that they don't ever, or only at very rare intervals, exercise that power. While the stalls remain in a particular site, the site is occupied by Smith. Reference to Salford.
But is that true also of the bookcases, I mean, these showcases?
Yes.
Where does he say that? Because they were much more easily moved around and probably not.
At the page 561, he's still talking about the bookstores. And then 566 is where he specifically comes to the showcases. And the point is about 8 lines down. I think these showcases are occupied by their owners by means of the goods which they exhibit. So far, I see no distinction in principle from the other premises which I have discussed. So he doesn't repeat every step seriatim. He simply says they are no different. And that's right. It's not the movability that matters. The question is never, could it be moved? It's always, has it been moved enough to be transient? And if you think about it, of course that's right if you're going to have a tax on occupation. The question is never going to be, well, did you have to occupy? Did you have to stay in occupation? Could you have moved around? It's always going to be, did you occupy? I'd better stop.
Yes, we'll sit again at 2 o'clock.